Hello everyone, welcome to LawEducate. I'm Shruti Mishra and I'll be your criminal law faculty. So at LawEducate, we provide you classes for all kinds of competitive examinations regarding law. So you'll get classes for your judicial services examination, prosecution officers, CLAT examination, then your regular college syllabus if you want help regarding that. So any kind of classes you want regarding law, everything will be provided to you. So today we'll have a demo class on Indian Penal Code. I will be telling you about different general aspects of the penal code of our country and will also be discussing about a general introduction to this penal code. So let's start. So Indian Penal Code 1860. So 1860 denotes the year it was enacted, okay? And now it is more than a century and a half, but still you'll find it very relevant. So the Indian Penal Code is obviously the official criminal code of our country and it is a substantive law. Why it is a substantive law? Because it defines various crimes, okay, and also prescribes punishments for it. So unlike the procedural laws such as the Criminal Procedure Code, which gives out the procedure for prosecuting an offense. So how will you go to a police station? How will you lodge an FIR? How will you proceed with the different procedures of the court? Everything you'll find under CRPC. All these sort of things, you will not get it under IPC because this is a substantive law. It only defines that if such and such act happens, this would amount to an offense. And if this offense happens, the person or the offender is going to get this amount of punishment. Okay? So this is how substantive laws work. And this is how our Indian Penal Code is also framed. So the first law commission prepared the draft of the Indian Penal Code in the year 1834. And it was prepared by the very famous, or you can also call him very infamous, Thomas Babington Macaulay. So he was the person who brought English education to the Indian soils, and he also brought different legislations that were English in nature to the Indian soil. So these English legislations were modified to suit the Indian scenario and then they were implemented in India. Okay, so thus we have our Indian Penal Code and it is now more than a century old. So elements are derived from Napoleonic Code and the Louisiana Civil Code of 1825. So our Indian Penal Code is based on the code that was prepared by the Napoleon in France and other European countries, and also Louisiana Civil Code of 1825. So if you have any knowledge about jurisprudence, you will also get to know that this penal code is prepared on the theory given by Jeremy Bentham. So what he discussed about punishments, how the punishment should be given based on the aggravating and mitigating factors, that is all how the Indian Penal Code is prepared. So you will see that a less serious offense is punished with minimum amount of punishment, and as the seriousness or the gravity of the offense gets higher and higher, the punishment gets severe and the punishment increases. Okay, now this penal code has 511 sections now, which is divided across 23 chapters, and they provide list of all the crimes along with the punishments prescribed for it. So what you see on your screen are different definitions provided by different jurists for crime. So Austin defines crime as a wrong which pursued by the sovereign or its subordinates. So if you know the definition of law given by Austin, you can connect it with this definition where he brings in the sovereign and he says that anything which the sovereign determines that this is wrong, that becomes crime. Roscoe Pound says, crime as a social phenomena carries a similar view that crime is what prohibited by the criminal law, which is in a sense protecting social interests. So Roscoe Pound, according to his social interest theories, defines crime and he says that it is a social phenomena. Crime is what? It is a part of society and it is something that is prohibited by the criminal law of the land. Why it is prohibited? Because it wants to protect the social interest, the interest of the society. Crime is something that hampers the interest of the society at large. Now, the Blackstone's definition. He defines crime as an act committed or omitted in violation of public law, either forbidding or commanding it. So he also says the same thing, that what is crime? It is a violation of public law. So either you're doing something that the public law is telling you not to do, or you're not doing something which the public law is telling you to do. So that becomes crime. Now we come to the definition of Stephen. He observed crime is a violation of right, considered in reference to the evil tendency of such violation and regards the community at large. So according to his definition also, crime is something which is hampering the interest of the community at large. So generally you will see two common elements. So first thing, crime is something that is hampering the interest or the conscience of the society at large, and crime is something that is against the law of the land. So similar to these definitions, this is how crime is defined or crime is understood even in the present societies. Okay, so crime, why is it prosecuted by the state? Because it is not only hampering the victim, it is injuring or it is causing harm to the society at large. Okay, so whenever a person is murdered or whenever any offense occurs, so it is not the victim who is getting affected. Along with the victim, the society at large gets affected. They feel scared, they become fearful. So that is why, on behalf of the society, it is the state that prosecutes the crime. Okay. Now let's see some essential ingredients how a crime is constituted. So if we go by IPC, so for a crime to happen, we first need a person who commits a crime. Okay. So without a person, a crime cannot be committed. Then we need guilty mind, which is known as mens rea. So mens rea is the Latin maxim for guilty mind. So if a person does not possesses any kind of criminal intention, he cannot commit crime. Okay. So his guilty mind or his mental intention is very much necessary for committing an offense. Then an act or omission. So accompanied with the guilty intention, a person commits an act or an omission. So act is something that he should not be doing, and omission is something that he was to do, he did not do. Okay, so this part is called the actus reus. Then with the guilty intention accompanied with the act or omission should cause injury to the victim. Okay, and after the injury is caused, the object of the crime is achieved, or we can say the crime is fulfilled. Okay, the crime happens. So if you see this picture on your screen, you can see that a person, he had in his mind that he's going to break the nose of the person standing in front of him. So what he does now, he is a person. So first ingredient is complete. Then second is he had the mental intention of breaking the person's nose. So second ingredient of mens rea is complete. Then the third part, when he is punching the person. So there the actus reus is complete. The fourth one, an injury. So when the person gets hurt, the victim gets hurt, the part of injury is complete, and thus the crime is completed and his object of harming the person is achieved. Okay, so I think through this example and through this picture, how a crime happens or how a crime is committed would be clear to you now. So let's discuss certain more facets of the essentials of crime. So section 11 of IPC tells us what is a person. So we discussed that first essential element of a crime should be that a person should be there. So who's the person? So section 11 of IPC tells us that person includes a juristic person or an artificial personality, which is a company or association or body of persons, and they might be incorporated or they might not be incorporated. And the persons do not include animals. Okay, so persons can be the natural persons, the real human beings that we know of, or the artificial juristic persons. Okay, this will not include animals. Then if we talk about the mental element mens rea, so the complete legal maxim for it is actus non facit reum nisi mensit rea. So this is applied in two ways in IPC. So positively, where you find the usage of words like intentionally, fraudulently, voluntarily, all these things in different definitions of different crimes under IPC, those denotes that the criminal intention or the mental element of mens rea should be present while commission of that offense. Okay, And negatively, you can find it in the chapter of general exceptions, which indicates that while doing such acts, the mental element or the criminal intention was absent. Okay, so the chapter on general exception precludes mens rea. Okay, whereas the different definition of various offenses which have the word like intentionally, fraudulently, etc., they positively talk about mens rea, that mens rea should be present while those crime is being committed, or else it would not constitute an offense under IPC. Okay, so this case law is very much important. State of Maharashtra versus M.H. George. This is a 1965 case, and here it was firmly settled by the Supreme Court that mens rea is an essential ingredient for criminal offenses in India. If something has to be constituted an offense and it has to be punished under IPC, first the mental element has to be proved. If the person did not had the intention to commit a crime and then he committed something which amounts to an offense under IPC, he cannot be punished for it generally. So we were talking about mens rea. So let's know the difference between intention and motive. So intention is what we were referring to as mens rea. So, intention refers to a purposeful action and a conscious decision to perform an act that is forbidden by law. So, as soon as you resolve in your mind that I know this is forbidden by law, if I'm going to do this, I will commit a crime and I'm going to be punished for it, still you form this mental resolve that I am going to do it. That is the intention part. Okay. Whereas motive is the ulterior cause why you are framing this intention. Okay, so let me give you an example. So if a person is very hungry, okay, and he decides that he is not going to beg for food, whereas he's going to steal food from a shop nearby. Okay, so his mental resolve that now I'm going to steal, that is his intention. And why he is stealing? Because he is hungry. So that is his motive. Understood? Okay, so intention is the objective for the crime and motive is the driving force, as you can understood by this example. Okay, the intention will always be expressed somewhat. Motive will be the distant factor for committing that crime and it will be implied. So intention is quite substantial in determining criminal liability of the offender, whereas motive is not. Okay, so mens rea only includes intention, it does not include motive. Now let's talk about various stages of a crime. So a crime starts with intention. So as soon as an offender frames a mental resolve that I'm going to do such an act which is against the law of my land and still I'm going to do it. So that is his resolve, that is his intention, and that becomes the mens rea. Okay. So the crime starts with the intention. Then comes the preparation stage. So once a person has resolved mentally that I'm going to do this, then he will start preparing for the crime that he is going to do. So after his preparation is complete, he will attempt to do the crime. And if his attempt is fulfilled, his crime is accomplished, his offense is accomplished. So if we take an example of theft, okay, so first the person will decide in his mind that I'm going to commit theft. Then when he decides that on what day and how I'm going to commit the theft, what are the informations required, what are the tools required for committing the theft, that would be the preparation stage. Now, as soon as he reaches the place where he wants to commit theft, okay, and let's say he wants to commit theft in somebody's house, so he enters the house, okay, and he's trying to pick up the things that he wants to steal. So that is the attempt part. Now, if somebody comes and gets hold of him, catches him in the attempt to commit theft, so his attempt will be stopped there. His offense or crime of theft will not be accomplished. Whereas if he's not caught, he's able to steal what he wants, then his crime of theft or his offense of theft will be accomplished and his all four stages of crime will be completed.